Greetings and welcome to the latest edition of Legal Bites, the official podcast of Cummings and Cummings Law, where we focus on helping businesses and their owners redomesticate out of volatile legal and tax environments to more predictable, pro-entrepreneurship, pro-growth jurisdictions. Today, we are reviewing the top 5 reasons why dissolving your company is usually a major and often irreversible mistake when you are considering relocating to a new jurisdiction. I will then conclude by explaining how small and medium-sized businesses and their owners can use the law to their advantage to relocate to a new state while keeping their federal employer identification number, contracts, bank accounts, and in most cases, their credit history intact. But first, a brief introduction. My name is Chad Daniel Cummings, and I am an attorney and certified public accountant serving clients in matters of business, tax, and commercial law. I am Chief Executive Officer of the multi-state, multi-attorney law firm Cummings and Cummings Law. And in addition to my day job, I also teach business and tax law at the university level. I hold 4 degrees, including 2 law degrees, as well as a bachelor's degree in accounting and a master's degree in taxation, in addition to 11 professional licenses and certifications covering accounting, tax, audit, and of course, the law. My firm website is www.cummings.law. Now, let's dive into the top 5 reasons why dissolution is not a relocation mechanism, but instead a going out of business maneuver. Reason number 1, the Federal Employer Identification Number, or FEIN, does not survive dissolution, contrary to what the so-called experts on Reddit might tell you. Believe me, I'm a tax attorney. I know what I'm talking about. The FEIN is the company's identity mark with the IRS. It is the number on every tax return, every W-2, every 1099, every bank account, and every vendor relationship the company has ever maintained. When the entity is dissolved, the FEIN is attached to a dead entity, to a corpse. The Federal Internal Revenue Service does not transfer a dead entity's FEIN to a new entity. There's no way to do it. The law does not allow it. A new company formed in the destination state receives a new federal employer identification number, even if the name is the same. That new number has no history, it has no filing record, it has no connection to the tax elections the original entity made. If the original entity elected, for example, subchapter S status, that election does not carry over to the new entity. A new Form 2553 must then be prepared and filed, and the timing requirements of that election may produce a significant gap in which the new entity is taxed as a disregarded entity, partnership, or subchapter C corporation. If the original entity had a fiscal year election, that election is also demolished. The new entity starts from zero with the IRS, and every administrative convenience that the original FEIN provided must be reasserted with the assistance of a tax professional. Reason number 2, contracts do not survive the death of the entity that signed them, at least not in their original form. When a company is dissolved, it ceases to exist as a legal person. Dissolution is the legal equivalent of the death penalty. The contracts it entered into are now agreements with a party that no longer exists. The counterparty's obligations may be dischargeable, but the company's obligations do not simply evaporate. Instead, they devolve. In most states, the liabilities of a dissolved entity, known and unknown, past and future, fall to the owners in their individual capacities. The limited liability protection that the entity was formed to provide is gone because the entity itself is gone. An LLC or corporation exists to stand between the owner's personal assets and the claims of creditors, vendors, landlords, and litigants. When you dissolve the LLC or corporation, that barrier ceases to exist. A customer who was injured by a product the company sold years ago can bring a claim. A vendor who was allegedly shortchanged on a contract can bring a claim. A landlord whose lease was purportedly breached can also bring a claim. Now, those claims will reach the owner's personal bank accounts, personal real estate, personal retirement accounts, and personal vehicles, maybe even little Johnny's college fund, because there is no entity left to absorb them. The owner who dissolved the company to save a few bucks on legal fees has risked everything by exposing everything to unlimited personal liability for obligations that they may not even know about. Hello, bankruptcy court. Reason number three, bank accounts are tied to and associated with the FEIN. When the entity is dissolved and a new entity is formed with a new distinct federal employer identification number, which is what the law requires, the bank will not simply update the account. Rather, the bank will close the account. The owner must then open a new account with the new entity, reestablish signatory authority, reapply for lines of credit, and reissue payment instructions to every customer and vendor who pays into or is paid from that account. Merchant processing and credit card processing accounts, payroll accounts, and automated clearinghouse relationships must be reestablished and renegotiated. Payment processors conduct underwriting on new accounts, and the new entity has no processing history. That's a problem. The result can be holds, reserves, reversals, and reduced processing limits that the original entity simply did not face because the original entity had years of transactional history. For a business that processes payments daily, this disruption is not administrative, it is existential. Number four, dissolution is often a taxable event. Under the Federal Internal Revenue Code, a liquidating distribution from a dissolved entity can trigger serious gains in the form of gain recognition at both the entity level and the owner level. That's a double whammy. If the entity holds appreciated assets, the distribution of those assets to the owners is treated as a sale at fair market value under Internal Revenue Code Section 336A. The entity also recognizes gain on the deemed sale, and the owners recognize gain on the liquidating distribution to the extent that distribution exceeds their basis in their ownership interest under Internal Revenue Code Section 331A. The same assets held in the same hands produce a federal tax bill that would not exist if the entity had not been dissolved and instead had been properly redomesticated. State taxes may also apply. Some states impose exit taxes, clawback provisions, or withholding obligations on dissolved entities. The owner who dissolved the company to save a few dollars and avoid hiring an attorney or CPA can easily owe more in federal and state taxes, sometimes by orders of magnitude on the dissolution, than it would have cost to hire a professional and handle the redomestication properly. Finally, reason number five, credit history and credibility do not magically transfer to a new entity. A company that has operated for years, maintained vendor accounts in good standing, carried insurance, and built a solid track record with lenders has a credit profile that took those years to establish. Dissolve the entity, and that profile is attached to a dead company. The new entity formed in the destination state has no credit history, it has no vendor relationships, it has no track record, it has no years in business. Lenders, insurers, and vendors evaluate new entities very differently than they evaluate established ones, as well they should. The interest rate on a line of credit is often higher for a new entity than for a decades-old entity with a clean payment history. The insurance premium may be higher, the vendor terms may be less favorable. The credibility the owner had spent years, if not decades, building is now extinguished in a flash, because the entity that built it no longer exists. Those are the top five reasons, but certainly not the only reasons. To briefly recapitulate, the federal employer identification number is severed. The contracts bind a dead entity, and therefore the liabilities can reach the owners personally. The bank accounts close, the dissolution can trigger taxes, and the credit history and credibility that took years to build are attached to an entity that is no longer extant. Every one of those consequences is permanent and every one of them is avoidable. With this context in mind, redomestication, let me say the word again because it's kind of a mouthful. Redomestication is the lesser known legal process of transferring a company's state of domicile to a new state without dissolving it, without creating a new entity, and without triggering federal income tax repercussions, but only when performed with the strict formalities required by the Federal Internal Revenue Code, applicable Treasury regulations, and the statutory frameworks of both the destination and departing states. When performed by a competent professional, and that is a very important caveat, the company retains its existing federal employer identification number, contracts, credit history, and bank accounts. That is to say, there is zero operational or financial disruption, but only if you get it right the first time. That is why it is so critical to work with a credentialed professional and save the DIY for home improvement. I have successfully completed redomestications from all 50 states and for limited liability companies, partnerships, Subchapter S entities, and Subchapter C corporations. So if someone is telling you it cannot be done, what they're really telling you is that they don't know how to do it. Now, foreign entity registration is not the same thing as redomestication because foreign entity registration, also referred to as foreign qualification, does not, repeat, not change the company's legal domicile. In fact, it does the opposite by keeping that entity in the former state indefinitely and merely adding another layer of compliance and tax obligations in the destination state, leaving you permanently anchored to the state you were trying to leave. Meanwhile, a traditional merger, which is also not the same thing as redomestication, creates a new distinct entity in the destination state, may require the issuance of a new federal employer identification number, and can trigger serious tax consequences. That is why we do not usually recommend a traditional merger as a relocation mechanism when better options exist. Finally, hopefully you understand by now, dissolution should not enter the conversation at all because dissolution terminates the company. Dissolution is, as I have explained, a going out of business maneuver, not a relocation mechanism. Dissolution is often a taxable event, and when performed inadvisedly, can expose the owners of the company to unlimited personal, yes, you heard me correctly, personal, joint, and several liability for the company's liabilities, known and unknown. That is because the so-called veil of protection no longer exists because the company no longer exists. If you think dissolution is a cost-saving option, you may be in for a rude awakening. And if you have a so-called professional suggesting dissolution as a relocation strategy, I implore you to seek better advice. Redomestication, when paired with the change of personal residency and that is an important and, a reduction or outright cessation of business operations in the former state, can reduce or even eliminate state tax exposure for the entity and its owners. Don't take my word for it, ask your CPA. And if your CPA doesn't have a clue what you're talking about, it may be time to seek better advice. Now is the time to consider acting as the various state legislatures are considering possible changes to their laws to hinder and in some cases even eliminate the option of redomestication. Therefore, if you have questions regarding potentially redomesticating your existing LLC or corporation, please use the link in the description for more information on this nuanced process and to schedule time for you and I to speak one-on-one about your specific scenario. Again, my name is Chad Daniel Cummings of the firm Cummings & Cummings Law, and I hope that you found this information helpful. As always, the information in this presentation, like all of my presentations, is necessarily general in nature and is not legal or tax advice, nor should it be construed as such, because that advice definitionally must be specific to a particular set of facts and circumstances. Should you have any questions regarding this information or the content of any of my many earlier presentations on these sometimes confusing topics, please visit my firm website at www.cummings.law, not .com, but .law to schedule time for a consultation. I look forward to that opportunity to speak and perhaps even work with you very soon.